Welcome back to Supreme Myths, and boy, am I excited today. I started this series because of the person who is my guest today. 118 episodes and years ago, Professor Jack Balkin of Yale Law School and I and a few other people were debating originalism on Twitter, of all places. And Jack generously said, why don't we talk about this more sometime, not in this particular place. I decided to do a podcast. Jack was my very first guest, which of course got me other great guests because of Jack's reputation. And now I am 117 episodes and 2 years later. So Jack Balkin, the Knight Professor of Constitutional Law and First Amendment at Yale Law School, is back. I know you've heard of him. He has written too many articles and essays and blog posts and all kinds of things to talk about. But his new book, Memory and Authority, The Uses of History in Constitutional Interpretation, could not be more timely given the court's focus on history and tradition, or I would put it alleged focus, but we can talk about that too. Jack, welcome back to Supreme Myths, and thank you for starting off this series 118 episodes ago.
Well, thank you for having me back.
I'm very excited. All right, so let's just start.
What's on your mind?
Too many things. I read your book. I reviewed your book for Dorf on Law. I thought it was very good. I have one complaint. We'll get to that at the end. Why did you write this book, Jack? Why did you write this book?
Oh, I tend to take a very long time to write books, and
No, you don't. Wait, stop. No, you don't. You've written like 12 books in 20 years or something. You write a book every 2 or 3 years, don't you?
Well, yeah, but you see what happens is that this book took about 2013, so I'd say 11 years.
Okay.
What happens is I have a bunch of different topics I'm working on. It takes me a very long time to figure out how the topics are, but since I have multiple topics in play at any point, the books come out quicker than you think.
Right.
Quicker than that.
Okay.
Anyway, this was a project I started about 11 years ago, right after I finished Living Originalism, and I was thinking about how we use history, since after all, Living Originalism has a very broad zone for construction, that is creation of doctrine and application. And so you use history for that. Well, how do you use history? So I started working on that, and I wrote a very long piece on that. But then I wrote more pieces. And then finally, after about a decade, I figured out what I really wanted to say about it. And so I put it all together in a book. So that's how the book came about. It was a decade's worth of thinking.
I mean, there's a compliment in that you've written a lot of excellent books. I was thinking, I wonder if there's any other constitutional law-ish book ever with the word memory in the title. I'll tell you, Jack, let me tell you why I say that. I'm a huge Stephen Sondheim fan. I know it's a non sequitur. And he wrote a musical called Sweeney Todd. And I read about that. And this is what he says. The very first line of the show is attend the tale of Sweeney Todd. And that word attend, Sondheim says it took him a long time. And he wanted to put the reader right in 19th century England, and the word attend, he could have said, here is the tale of Sweeney Todd, or come listen to Sweeney Todd. But he said attend. You picked the word memory, and that's such an interesting choice. And I'd like you to explain that.
There is a small literature about memory in the law review literature. Mm-hmm. My colleague Reva Siegel, a dear friend of mine, who I talked to over many, many years, she has written on memory, some brilliant things on memory. But yes, it's true. Most law professors don't talk about memory. And one of the things this book will do is put the word memory in people's consciousness so they'll think about it. And the reason why is because, by the way, there's a huge literature on memory in the humanities and the social sciences.
Sure.
So just not in law.
Yeah.
Because memory is not about applying the past like a rule. It's understanding that the past is a thing that's constructed. That's something that communities have. There's a cultural memory of things, and these things basically connect a community, or that they have common values that people argue about and talk about, and common stories. And so in other words, it's a cultural idea and a sociological idea. And those are things that doctrinal lawyers don't spend too much time about. Similarly, people who treat history as a command, that is, well, that's what they did, so we must do that. They're not going to use the word memory because it's a cultural idea or a sociological idea, and it doesn't do what they want it to do, which is they want it to be a command. And so the very use of the word memory is already to put in question what history does in law and how it works.
I love that. And I honestly, sincerely believe it's a great title for that reason. I'll tell you how it hit me personally. I turned 65 last year. I know you're 67, I think. So we're roughly the same
Yeah.
age. And what I've noticed about myself and my peers, my friends, my age, is that my memory is much worse. It just is. It's my memory, things I thought were true, things I would have sworn were true, are not true. And that's happened to my friends. It's happened to me. And so I love the idea. When people think of memory, I think of it as imperfect. Is that how you think of it?
Well, memory is selective
Yes. Yes.
and memory is constructed.
Yes.
Right. So in other words, we put together different parts of our experience and they form memory. And third thing is memory is shared. People have common memories,
Yeah.
right? And then the fourth thing is that memory is handed down. So you have memories, cultural memories of the Civil War. You didn't fight the Civil War. You have cultural memories of the Revolution, what you think happened during the Revolution. You have cultural memories of the founding. You weren't there at the founding, but you still have memories of it. You have cultural memories. These are things that are collective tales collectively told about the past, which are handed down through the generations. So those are four features of memory. And you
Jack,
can see, go ahead.
I got a tingle there because the very last line of my brother's toast to me at my wedding was, "Here's to collective memories, shared memories." That was the last line.
And memories are things that bind a group together, a small group like families, a larger group like a company or a corporation, an even larger group like a political organization or a nation. And the existence of the shared memories helps bind the group together. But memories, the last thing I want to say, the fifth thing I want to say is memories are contested.
Yes.
So when you talk to your family members about things, they'll see it
Yes.
differently, what happened.
Yes.
And when people talk about the founding or the Civil War or Reconstruction or the New Deal or other key events in American history, they'll have different stories they want to tell about it. They'll emphasize different things as opposed to other things. And that's a feature of memory. So that what we have is things that are shared, are constitutive, help constitute a group, but also are objects of dispute. And the disputes that people engage in about memory are often tied to their values. They're often tied to what they think is very important and how they want to go forward into the future. So remembering the past is a way of fighting about going forward in the future.
So to make our formalist, textualist, originalist friends happy, why don't we also memory and authority, the uses of history and constitution? What do you mean by authority, and why choose that word?
Well, what are lawyers really doing with the past? Why do lawyers care about the past? The answer is lawyers are seeking authority. They want to make arguments, persuade people, and they want to convince other people that this is what the law means or should mean or should be changed to mean. And so they need to find authorities in order to persuade people about the law. So one of the major uses of the past is to establish authority, is to give authority. And that's true, by the way, whether you're an originalist or not an originalist. So people who are not originalists use the past too in order to establish authority. And you can establish authority by saying they did it this way, we should do it that way, or they did it this way and we shouldn't do it that way, right? So there are many ways in which people use the past in order to establish authority for the legal claims they want to make.
The only person I've met in my legal world over 34 years who believes or believed history is effectively irrelevant to constitutional law is Richard Posner. But he's the only one. I have never met anyone else who said, "I don't want to hear anything about history. Don't tell me it's irrelevant." That's originalists sometimes make that a straw man for non-originalists, but it's not true. I mean, I'm as there's a place for history in law. There just is, and I think that's universally accepted, except for by Richard Posner. The question is, what's that role? And that's the point of this book, right? That's right. Really the point of this book.
And part of the book, you should understand,
yes.
the book has many criticisms of
yes.
conservative originalism, but
yes.
a lot of the book is actually not directed toward conservative originalists. It's directed toward my liberal friends, progressive friends. And I want to tell them that they need to pay attention to history. They should use history. They shouldn't fight shy of history. They should even make originalist arguments on occasion, because what's at stake in fights over the past and fights over memory is the future direction of the country, and the values that are going to be embedded in the law. And as I say at one point in the book, if you let other people take charge of history, then you'll be living under their version of history, and you'll be living under their version of values. So everyone has a stake in the cultural memory of the country. Everyone has a stake in the past and what the past means for us today.
Jack, what I find kind of interesting, and I'm sorry, this wasn't part of my questions to you in advance, but, the way you just put that, and when I read your book, I had this feeling too. You just said you wanted to explain to liberals and progressives that they should find a place, for history when appropriate, use it when it helps, and that kind of thing. In 1969, at the height of the war in court, you wouldn't have had to say that. You wouldn't have found a liberal law professor in America who would have thought history was irrelevant. You would have found pluralists. You would have found people who thought text, tradition, history, precedent, values, consequences, all of that gets mixed up, and you come out with an answer. But today, and I think our generation still feels that way, but I do think there are 40-year-old law professors out there who are progressive who want to throw history in the garbage can. And I take it a big part of your lifelong career project, based on your book, Living Originalism, is to dissuade them from doing exactly that.
Yeah, I mean, I think you're being somewhat unfair to 40-year-old law professors. There
Okay.
are many, in the legal academy, as you well know, one of the most important interdisciplinary subjects that lawyers engage with is history. So there are many lawyer historians. There are many PhDs, history PhDs in law schools. Many people teach legal history. They care about history a lot. But you're right that a focus on doctrine as the central issue in constitutional law will distract you from deeper questions about the meaning of the Constitution and the meaning of the American past. And so, yes, you can't go into disputes with other people about the meaning of the Constitution armed only with doctrinal tools. The reason why is because people on the other side will invoke history, and they will invoke tradition as a way of saying, I don't care about your doctrine. Your doctrine is all wrong. Let me tell you about the meaning of the Constitution, or let me tell you about our traditions as a people. So they go to something deeper and older as a means of trumping doctrinal arguments and overturning them. And that's why, by the way, throughout American history, the turn to the past, to tradition or to original meaning or original intention, has been the classic way of picking apart and overturning precedents. This was true for conservatives, but it was also true for liberals before them. So Hugo Black, original intent originalist, used history to overturn or to criticize existing doctrines. The Warren Court, many of the Warren Court decisions use history as what was called a precedent-breaking device, because, of course, they overturned many old precedents, and they turned to history as a way of justifying it. And so guess what? The conservative legal movement is a revolutionary movement. It's not a Burkean movement. It's a movement that wants to overturn and change things relatively quickly. So they turn to history too, in an attempt to try to trump existing liberal precedents and substitute conservative ideas.
Professor Frank Cross, my audience should know, wrote a book. Now it's pretty old. It's like 10 or 12 years old, I think. But the Warren Court used historical references at one point in time, according to Cross, more than the Rehnquist Court, which is a very interesting observation.
The reason why is because they were a court that was trying to change things. They wanted to change, they wanted to clear away a lot of things they thought were unjust and inappropriate. So they turned to history to do it. Alfred Kelly, who was a famous legal historian during those age, when he writes about Clio in the court, a very early attack on the Supreme Court's use of history, he's not attacking conservatives, he's attacking the Warren Court. He says, you're making things up, you're using history badly. And I know why you're doing it, Kelly says. You're doing it because you want to overturn precedents you don't like.
And that's certainly what the Roberts Court is doing. Jack, let me ask you a really big question, and it may be too big for even this forum, but let me try it. So you just made a descriptive claim. I believe this claim you made was mostly descriptive. You might mean it normatively as well, but you definitely meant it descriptively. This is what has happened throughout American history, I think is what you said, or something close to that. I'm sorry, but it's my pod. I get to go back to Posner for a second. So, leaving aside the descriptive claim, which Posner would agree with, um, normatively he would say, and did say in his last book, which was written when he was sick, so it's not that great a book. But his point was the legal profession in America is a backwards-looking profession to agree that it's dangerous and harmful. And to Posner, who would also concede his court is bound by the Supreme Court, and the district courts are bound by his court, and judges should be bound by higher courts. But he would say, we don't care about yesterday. Let's do what's best for tomorrow. That's what we need to plan for the future and do forward-looking things. And for a Reagan conservative to say that is kind of interesting, but that's what he told me 1,000 times. Normatively, do you think, like, if you could with a wave of your hand say, you know what, we'll use history symbolically at times to align ourselves, but as far as generating decisions, no, forget history. We're going to do what's best for America tomorrow. Would you make that move?
I don't agree with this. Let me just say that
yeah,
Posner, when he was saying these things,
yes, well, sent to me privately too.
Yeah,
yes.
I know, but this is in his work.
Yes,
he was echoing an important idea from Oliver Wendell Holmes.
Yes,
and Holmes viewed that you should cynically discard old traditions that had outlived their usefulness, and that in a famous essay, the Path the Law Holds says, and I can't quote it exactly, but it's something of the effect of, it's nothing's more revolting than having to do something simply because it was done that way in the years of King Henry, right? In other words, the idea that you would be bound to follow something simply because it was old was odious to Holmes. And his idea is that you should take a fresh look at things and understand what's appropriate for our time. That's what Posner is saying, and I agree with it. But here's the place where I would disagree. You need to understand what has happened in the past. So for several reasons. First of all, you're part of a community. The community has values. Those values are constitutive of the community. And in order to understand those values and what they mean, even if you're critical of them, you have to understand the past. So even if you want to be critical of the way things are, you have to understand the past. This is an important point about memory. Memory tells people who did what to whom and why it mattered. And
right.
If you put things down the memory hole so they're forgotten, then bad things that happened in the past, injustices that happened in the past, mistreatments and oppressions that happened in the past can make no moral claim on you today because they never happened. We never had this conversation. We don't talk about Bruno. So if you're interested in producing justice, if justice is what you're after, then you really need to pay attention to the past, and especially the parts of the past that have been flushed down the memory hole. You need to be, as I say in the book, as many lawyers are, memory entrepreneurs, people who get people to remember things that happened in the past, but that were forgotten or misremembered. I'll give you a wonderful example of this. Think about the long history of the struggle for Black civil rights in the United States.
Still going on.
Still going on.
Yes.
The North won the Civil War, but the South won the battle over memory.
Yes.
And for many years, they told a story about the Civil War and Reconstruction, which made it seem that Reconstruction was a big mistake and it was thoroughly corrupt, and the values of Reconstruction were the wrong values, and that in fact America, the Civil War, well, that was just brothers, white brothers really, who had a feud, but they settled it and everything is fine now. And there's an entire school of history, the Dunning School, which basically retold the story of Reconstruction and the Civil War in a way that was consonant with the interests of conservative whites with respect to race. That's about memory. That's about the past. And if you let somebody else tell you what happened during Reconstruction, if you let somebody else tell you about what happened in the 19th century and the 20th century, well, then all these claims, all these questions of justice are going to be flushed down the memory hole. And so it's very important to recognize that not as the civil rights movement, the modern civil rights movement that begins after World War II is ramping up, historians are beginning to retell the story of Reconstruction and the Civil War. And a new generation of historians, of which the most famous is Eric Foner, begin to write stories about Reconstruction. Now, of course, Du Bois had written a history of Reconstruction before Foner, right? But it's really with Foner and successive historians that the story is told. And it's crucial crucial in understanding claims of justice for Black Americans today, to remember what happened in the past, why it happened, who did it, and who suffered under it.
Jack, I want to make two observations. One is, first of all, I want to make sure everybody understands that this book is an essential reading in this moment in time because it's essential reading, period. That's point one. Point two, the Supreme Court is turning to history and tradition in its rhetoric anyway, in a way that it has not done in a long time. So Jack's book also, we're going to talk about that in a second. But third, as is true for almost all of your books that I've read, originalists will read this and go, I like that, but I'm not so crazy about that. And living constitutionalists will go, I like that, but I'm not so crazy about that. And I think that's a real talent you have. And that's why this is not like, some of us who write in a more one-sided way. This is a book for everybody. And I think everybody should read it, lawyers and non-lawyers. And the last thing I want to say, Jack, I'm from New York. I was raised in Long Island. I come down to Emory in 1976. And in 1976, I meet my first Southerner who I've ever met, and we become very close friends. His understanding, and very highly educated, good high school from Tennessee. I'm from a good high school in New York. His understanding of the Civil War and Reconstruction was so different than mine. It was like we read two different books on the subject, and each one took a very different view of what actually happened. And I was shocked that this fairly moderate to liberal person had a view of Reconstruction and the Civil War that to me sounded insane, almost. I mean, that it's not what happened. It's just not what happened. So I think your point is incredibly valid here. We have to correct, I think, a misapprehension or a misreading of Reconstruction. And that's what Eric is trying to do, I think. Do you agree with that?
The general point, and this is the general point I would say to Posner, is you can't do justice to justice without doing justice to the past.
Okay. So I want to talk about tradition and the Supreme Court. But before we do that, Jack, because there are people listening to this who are not as up to the literature as other people may be listening to this, I need you to define your view of constitutional interpretation is framework or living originalism. Just give us a quick definition of that, and then we'll move on to tradition.
Okay, framework originalism, two parts. First of all, originalism is a family of theories that said that there's something that is fixed in the time of adoption, whether it's intention or its meaning or law. Something is fixed at the time of adoption. That thing continues as law until such time as it's changed lawfully, for example, by amendment or a new convention or something like that. So I'm an originalist of that sort, but what I think is fixed at the time of adoption is just the framework. And what's the framework? The framework is the text, the semantic original meaning of the text, and the choice of whether we have rules, hardwired rules, whether we have standards like reasonableness, unreasonable searches of features, or principles like freedom of speech, equal protection of the laws, etc. So the framework is what's fixed, but the framework won't resolve most of the important disputes that happen in the Constitution. So you have to do something else, which is you have to construct doctrine over time. And that's exactly what the history of constitutional law is. If you look at a big, thick book of constitutional law, a constitutional law casebook like mine, it's full of constructions. I mean, the text is there for the first, 15 pages, but my goodness, most of the book is the constructions, history of constructions. So I'm a framework originalist in the sense that the framework, that's fixed, and the only way to change that is amendment. But construction, that's the history of constitutional development in the United States. That's basically what it is.
Is there any space between the word, as you're using it, construction, and the word application? Because what I found, Jack, in my journeys is non-lawyers understand application much faster than they understand construction.
Yeah, I think so. It's just that if you think about, for example, the law of freedom of speech, because I'm a First Amendment lawyer.
Yeah.
It's not like you're taking the text of the First Amendment and applying it in each case. What you're doing is you're building a superstructure, a lattice work of ways of solving certain kinds of problems. Here's how we deal with defamation. Here's how we deal with protest. Here's how we deal with picketing. Here's how we deal with campaign finance. Here's how we deal with associational freedom. And so all of this is built on top of the text, and that's what gets applied in case to case. Now you can see that since That's what the framework is. The lattice structure built over the framework of all these precedents and doctrines. You can now see how history is going to be used to attack it. So let's suppose you don't like a particular set of doctrines that have been put in place. Well, you want to change them. You want to distinguish them. You want to overturn them. You want to substitute new doctrines in their place. These doctrines will also be applications of the text. So how are you going to justify changing them? Well, one way that people do that is by hearkening back to the past, either to a claim about what the original meaning of the text was, or to a claim about our traditions as a people, or to a claim about injustices that happened in the past that we should never let happen again. These are all ways the past is used to alter or change the doctrinal structure that sits on top of the framework.
When Justice Kagan at her confirmation hearing famously said, "We are all originalists now," at a different time and date, she said, "We're all textualists now." I don't want to talk about that. But she said, "We're all originalists now." But that line was in a paragraph that what came before and what came after was basically her saying, where the Constitution is specific, clear, we apply it. President has to be 35. Where they lay down broad principles, I think she even said this at some point, that's the framework we use to decide cases today, but those broad principles don't define themselves. You have to construct them. She didn't say construct, but that was the meaning of what she was saying.
Yeah,
I
think that what Kagan is saying, and it's not just her, Chief Justice Roberts said something similar at his confirmation hearings.
Yes.
It's kind of standard practice. It's the standard way most lawyers understand the Constitution and the job of constitutional lawyers. And framework originalism is consistent with that. It's, in fact, if any way, it's kind of like a theorization of what I consider to be common sense about the Constitution. And the fact that lawyers would deviate from this common sense view is what leads to a whole bunch of disputes about interpretation.
Yes, I agree with that. I also want to point out that what you're saying today, what I believe Kagan said in 2010, you said this is how it's been done, this is what lawyers do. I think one of my bigger contributions of my career is finding this 1900 Law Review article written by the first person to ever use the phrase living constitutionalism. And he asked the question, why do interpretations or applications or constructions change over time with a fixed document? He said that's the biggest problem of constitutional law. He didn't use the word originalism, but he did say, what do we do with...
It's a problem. I don't think it's a problem. I think
okay, but he meant how you solve it. Fine. But he was just, but then he goes on to say about the Eighth Amendment's cruel and unusual punishment clause, a reasonable argument could be made it should be cruel and unusual when written, and a reasonable argument could be made that it's cruel and unusual today over time. And that's everything about that is okay because of the principle is kind of a framework. And as long as we operate under that framework, we're doing the right thing. And that's the year 1900. I mean, that's a long time ago. So I think what you're saying was common knowledge, or at least common practice, in the year 1900, which makes me think what you're saying is exactly right as a descriptive matter again. I think that's exactly
right. And I should just point out, the closer you are to the founding, the more people will simply make appeals to precedents of what was done early on.
Yes.
But that's not a claim that's saying that they're not applying a framework. They're just using precedent and past understandings as an argument for constructing the Constitution. It's really important to understand that when the first Congress sits after the Constitution is adopted, they have nothing but construction to do.
Right.
That's all they're doing. They're basically figuring out how to make this thing run. So they're engaged in construction. Are they engaged in original intention? No. Are they engaged in original meaning? No. Because who are they going to talk to? Themselves. They're constructing it. Right. So there's a dispute, an argument. Were the founders originalists? Well, no, of course they weren't originalists. They were originals. They were the people who were starting things. They couldn't be, well, what do we think? What was our original intention? No, that's not how it worked. People would occasionally make claims about what happened in the convention. That was not considered to be a good thing to do, but people did it. But basically, they were trying to decide for themselves how to make this thing work, how to make the thing operate. And so from the beginning until the present, the history of constitutional law is the history of constructions built on a basic framework.
Just for the record, what you call constructions, I would probably call something like ideology, but it's okay. Let's not get there
No,
yet.
no,
Let's
no,
not
no.
get.
I don't think so. Let me give you
I
an
know, I know,
example.
I know, I know, I know. I don't want
I
to.
just
Let's
want to
get.
give you an example for the folks at home. In
Okay.
my view, the National Labor Relations Act is a construction passed by Congress to fulfill various constitutional purposes. And the National Defense Acts are constructions by the political branches to fulfill various constitutional purposes. That a lot of constructions are institutions, laws, conventions, and practices which make government work and perform various constitutional functions. So these are not ideology. They may have been passed by people with particular ideologies, but they themselves are institutions, practices, and departments. They're made, they're constructed, they're built out. And so when I use construction, I mean not only the application of a doctrine to a set of facts, I mean the building out of a state over time in order to fulfill the purposes of a constitution. That's what
I should have said I meant when judges do it.
Yeah, judicial
when-
constructions.
Yeah.
Judicial constructions are influenced obviously by the judge's ideology and their politics. Nobody denies that. I'm a legal realist. You're a legal realist.
Yes.
But what they produce is a doctrinal structure which people learn in law schools, and which people, whether or not they have the same ideology as the judge, can apply and argue about in successive cases. So in that sense, the set of constructions, the doctrinal rules and principles and standards, those things exist whether or not the judge who produced them had a particular ideology.
So your book talks a lot about tradition, history, memory, and the past, and I found it just a fascinating enterprise. And in Dobbs and in Bruin, the court spends 50, 60, 70, a lot of pages talking about the ancient past, even the 1300s in Dobbs, I believe, or 1700. But anyway, way back. And they're doing so.
Alito wants to party like it's 1399.
Yes, he loves Matthew Hale for some reason. I'm not surprised. But anyway, with different conversation. What I want to ask you, I think, because this is, as you mentioned, we were talking before we started taping, tradition seems to be all the rage these days. People are writing books about it. I was invited to Notre Dame to talk about it. The court is referring to it. I love your book's critique, kind of the Bruin, Dobbs, throw everything of set in 700 years on the table and try to figure it out. What are your major issues with that type of legal analysis? I think Bruin and Dobbs are pretty similar in that specific way.
Well, I don't have a problem with making arguments from tradition. I don't have a problem with making arguments from original meaning, purpose, intention, right? These are fine. These are all part of the lawyer's toolkit. Lawyers make arguments about tradition all the time. Liberals like to make arguments about the tradition of liberty. They like to make arguments about the tradition of freedom of expression. That's fine. No problem. Tradition is part of the toolkit. The recent turn to tradition that you see in Supreme Court decisions by the new conservative supermajority, well, that actually,
wait, hold on. Oh, wait. What'd you call it?
The new conservative supermajority.
Oh, I thought you said conservatory. I'm sorry. Okay, good. I'm glad we straightened that out. That came out blurry the first time. Okay, go ahead. Sorry.
Maybe it's conservatory. I don't know.
That's what I thought you said, so I was surprised.
Supermajority. That actually has just made more clear what was always true of the conservative legal movement's invocation of the past and originalism. That is to say, although the official theories of originalism were about what was the original meaning of a certain text, or what was the original intention of a certain group of framers or adopters. In fact, the conservative legal movement has always yoked notions of respect for tradition and respect for the past to its invocation of originalism. So, although I just want to point out that the official academic theories of originalism are not about tradition. They're
Right.
about what happened at a particular point in time, what was the meaning at a time, what was the understanding at a time, what was the law at a time. In practice, judges on the bench, lawyers making arguments, right? Politicians invoking the past. We're always making appeals to tradition, to national ethos, to honored authorities like Madison or Jefferson or Hamilton or the founders. That was always going on. And
Right.
so, and so there was this disconnect between the official theories of originalism and what conservative lawyers were actually doing in practice. And all that's happened, and by the way, this is not original with me. Jamal Green made this point,
Yeah.
and various other people made this point too. But Robert Post has made this point. Um, Mike Dorff has made this point in different ways. And other people, I'm sorry if I've forgotten them, but I mean, this
It's
is
okay.
a familiar point.
Yeah.
Um, all that's happened is it's just become more obvious. And the reason it's become more obvious is that you have lots of conservatives now on the Supreme Court and in the lower federal courts, and they all have slight disagreements with each other about how to do things. And so now appeals to tradition are a kind of way of cobbling together majorities for cases. That's one point, because Alito likes to talk about tradition. But second of all, appeals to tradition, if you describe them correctly, or incorrectly, depending upon your view, if you describe it in a certain way, they'll basically get you to the conservative agenda of the present. So in other words, by invoking tradition in a particular way, you, in cases involving the Establishment Clause and religion and guns and sexual morality and sexual freedom, if you use the tradition idea in just the right way, you can basically mirror the current conservative views about law and about policy. That's exactly what this supermajority is doing. And that's why tradition is getting invoked in Dobbs, which is not an originalist case. It's a case about Glucksberg and the Due Process Clause, and Bruin, which is nominally an originalist case, but basically makes a hash out of academic theories of originalism. Tradition is being invoked here basically to make the law, change the law so that it conforms to the values of conservative lawyers.
So, Jack,
And by
I
the way,
will,
I just want to point out, that's what lawyers do.
right.
Lawyers tell the story of the past in order to promote the values they think are important. You now have 6 conservative lawyers who are basically engaged in a constitutional revolution, changing doctrine in many different areas at once. We've had constitutional revolutions before. This is another one. And here they're retelling the story of the past, sometimes in ways that I think are quite tendentious, in order
Yes.
to justify their values and what they think the Constitution means and should mean. That's what's going on.
So, Jack, I really wonder if we had either Clarence Thomas or one of the other self-identified originalists on the court here, Kavanaugh, Gorsuch, or Barrett. I don't put Alito in that category. If we had those 4 justices here,
Oh,
and
wait
we
a second.
said,
Alito's the most important guy.
hold on.
He's Mr. Tradition.
I'm asking. Hold on. Okay, throw Alito in there too. And we said to them, the New York law that you voted to strike down in Bruin was effectively passed in 1911. There was a Texas law that was identical, just about, from 1860 or something, 1870. Some very close to the 14th Amendment.
Yeah.
And the other 50 laws you distinguished in various, not 50, but many laws that are similar that you distinguished in similar ways. Just give us some time and we'll show you that any definition of tradition suggests your analysis there was off, was not accurate. Because why is a century-old tradition in New York not a tradition to respect? It's 1911. Well, it's a long time ago. The law's been on the books ever since. What would they say? Like, why not respect that century-old tradition?
Well, if you want to talk just about Bruin, let's talk about Bruin and not about Dobbs.
Yes.
I think Thomas's answer would be we're only interested in the traditions contemporaneous with either, this is another weakness of the opinion, 1791 or 1868. That is, we're trying to give effect to the original meaning of the Second Amendment. And therefore, we are interested in the traditions of regulation, which are roughly contemporaneous with, either a little before or a little after, those periods.
But he went back
Now, of course,
300 years. But he went
I
back
know,
300 years.
because what he's trying to do is he's trying to claim that the tradition was clear and settled at the relevant time. By the way, I have a big problem with this claim that you can smush together 1791 and 1868.
Me too.
I have a big
Me too.
problem.
Of course.
But
Of course. Of course.
And in fact, at one point, Justice Barrett says, well, we're going to have to decide this question at some point.
I know.
Thomas
Yeah.
says we don't have to decide it because it was all the same tradition. And
Yeah.
that's why he goes way back into the past and way later, because he wants to claim that there was a clear, coherent, and unitary tradition.
It's a frivolous
of
claim.
regulation.
It's a frivolous claim. There's no historian who
say-
agrees with that claim.
Yeah, I mean,
Okay.
it is an invented tradition.
Okay. So
In the
what?
sense, to use Hobsbawm's phrase, it's not real. It's a story that's being told, and it only works because you neglect important data points and describe them out of existence, and you tell the story in a way so that it corresponds with your imagination of what the past really must have been like. So in the mind of the majority, people living at the time of the founding, they loved guns and they weren't afraid of guns at all. And they shot them all the time. And people weren't really afraid. And they thought they were very important to liberty. And that's what was happening. But that's not actually what the history suggests. The history suggests that people understood guns were dangerous, that people would get killed, that even guns that were less powerful than the ones we have today were considered dangerous. And people took all sorts of steps to protect themselves from guns. So enormous amounts of history has been done on this, and I won't repeat it here. But that's just a different story about what the past was like. But it's not going to convince Thomas. He's quite convinced he knows what the past must have been like. And not only is he convinced he knows what it must have been like, he has many, many friends of the court, that is, people writing amicus briefs, who are providing the history that he can plug into his opinion. This is another point that's, I think I should stress at this point. The role that the parties and the amici play in doing the historical research, which is going to then be cherry-picked and applied by the justices. There's a key moment in Bruin in which Justice Breyer, in dissent, says, we're not very good historians. We can't do the historical work that's necessary to actually figure out what the tradition of regulation was, which is the test you want us to use. Thomas says, not a problem. You don't have to be good historians because we rely on the principle of party presentation. Which means,
by the way, Randy. Randy wrote that's Randy Barnett 5 years ago. Randy wrote that 5 years ago, and I believe Thomas is picking up on Randy's suggestion. Go ahead.
Well, yeah, but the principle of party presentation is a misuse of the term. Party presentation means the court only considers questions that were presented by the parties.
Yes,
and
I'm aware. Yes.
But that's not the way Thomas is using it here.
I know. Or
Thomas
Randy.
is saying we rely on the history that was presented by the parties and the amici. And of course, the parties and the amici are not disinterested historians. They are people trying to win an argument for their clients or the interests that the amicus represents. And so as a result, they're going to produce a particular account of history designed to favor their clients' interests or the interests of the parties they represent. That's the first point. So this is not a good thing to draw your history from necessarily. I mean, some amicus briefs are excellent, but many of them are less than good. The second point is, faced with dueling histories from liberal organizations and conservative organizations, from people in the Federalist Society network and people outside the Federalist Society network, from pointy-headed liberal academics and conservative think tanks, who is Justice Thomas going to trust? Who is he going to trust to derive his history from? He's not going to go to the liberals, he's going to go to the conservatives. Why? He's part of the Federalist Society network. He trusts these people. He thinks they're smart. He thinks they know what they're talking about. And so as a result, what decides the case is his imagined idea of what the past must have been like and those sources he trusts. That he
Jack,
thinks
I think I'm not sure I agree with I agree with everything except the last sentence. I think that if Harlan Crow produced absolutely ironclad evidence that everything, or whether it's Harlan Crow or you or an NRA paid consultant, whoever, if Thomas was presented with conclusive evidence that there were 100 identical laws to New York's law in 1791, and that they just missed it. Historians missed it. Everybody missed it. And in fact, there's a long, written, clear tradition. It doesn't change his mind at all. Nothing changes. He just writes the opinion differently. The result does not change.
All right, but notice what you just said. I'm not necessarily going to disagree with you. He writes the opinion differently. So in other
Yes.
words, instead
Yes.
of coming up with a test of history and tradition, he'll use a test based on, well, we decided Heller, and this is what Heller says, and so it'll be a doctrinal opinion. Okay,
Well,
I'm not surprised. But that's another point that's quite relevant, which is, I say it in the book, but I'll say it here.
yeah.
American lawyers, including both conservatives and liberals, are cafeteria originalists.
Yes.
In the
I love that
sense
phrase. Yes.
They choose to invoke the past, whether it's tradition or original meaning or law or intent, only sometimes, but not always. And when they find the history inconvenient, they use other modalities.
The major question doctrine, West Virginia versus EPA, and 5 other cases, there's almost no history in any of them. In fact, in all of separation of powers, in all of Roberts' striking down of agency arrangements, there is no history. And all of the originalists are signing on.
Well, there's a little
Not
in
much.
Saylor law, but it's not really what drives the opinion, because
No.
if you just went by Saylor law, if you just went by the decision of 1789, itself what the contested meaning is,
Yes.
you wouldn't end up with the distinctions that Roberts makes in Saylor
Yes.
law. So the
Yes.
decision of 1789 is the key founder's history he uses, but you can't get to the actual results in Saylor law from that history.
And by the way, Justice Jackson basically told us that in his concurring opinion in only the most famous separation of powers case of all time. I mean, in Steel Seizure, Jackson says, we can't do this. We can't go back. It's not going to work. Jack, I got to ask you a question. So are there constitutional disputes that end up in Supreme Court, that's going to end up in the Supreme Court, where history is functionally irrelevant? So let me give you an example.
All the time.
All the time.
Well,
Okay.
yeah, I should just say, it depends on which kind of history you mean, but I assume you're referring to founders' history or something
I
like
mean,
that.
anything. No, I mean, is there anything prior to 1950 in American history to tell us what to do with the internet on 10 different levels? I'll give you one. Just forget First Amendment. Civil
Oh,
procedure.
Oh, sure.
There,
Yeah, because remember, we're human beings of limited abilities
certainly.
and limited imagination. We have to build on something else. So generally what we build on are analogies from the past.
Fair.
And this is just in the lawyer's toolkit. That's history. It's not necessarily founders' history. It's not necessarily traditions of our people, but it's history that we build on. And you have to do it because you can't make up the entire world from scratch. You can't imagine a whole system of telecommunications law from scratch in each case. You have to build on analogies to what came before. And that's what we do. As I say, I teach First Amendment, I do telecom, I do internet law. We're always making analogies. That's fine. It's okay. That's what we do.
Jack, what would so Judd Campbell, among others, has clearly laid out that virtually everything we know about the First Amendment cannot be justified on an originalist basis. Prior restraint.
What he showed, and
Yes.
it's more general than just the First Amendment,
Yes.
is that at the time of the founding, judicial review is relatively weak.
Yes. Well, wait a minute. I said that long before Judd, but go ahead. Go ahead.
Other people said it too.
Yes.
That,
Yes.
that notions of your natural rights, people had notions of natural rights, but natural rights were regulable for the common good.
Yes.
Here, Adrian Freeman will be very happy to hear that.
Yes.
Were regulable for the common good, and that
Yes.
legislatures were expected to be the primary guarantors and shapers of what your rights were. That's why the legislature was the most powerful branch of government. And that's basically the assumptions that people had at the founding. So the idea of a strong judicial review as the central guarantor of rights and protector of rights, that's a later development.
Yes.
It's a development that occurs, I should point out, because of decisions made by politicians. Politicians construct the strong judicial review that we now live under. It's not just simply a series of power grabs by greedy, power-hungry judges. It's rather that decisions are made, especially after the Civil War, by Republican majorities who want to protect the civil rights of property owners as well as African Americans who construct the system of the federal courts and federal jurisdiction we have today. And over time, and with the 14th Amendment, that produces the modern conception of judicial review, which is very strong. It has no analog. It's a very different notion of judicial review than you had at the founding.
So what I find, so my first book lays that out, and the second one goes into in greater detail. The Dean of Georgetown did a lot of good work on this, and I think a lot of his history is valuable to look at, Dean Traynor. But what I guess I want to ask about that is, so we get the Warren Court, and then we get Raoul Berger, who's and Robert Bork and a few others, who, I don't want to get hung up on this claim of mine, but it's my claim is that they were using originalism as a tool to get to deference, not as a standalone thing. Their critique of the Warren Court.
You can use it in both ways. You can use it in either way.
Fair enough. But here's what I want to ask you about. Who I call the original originalists, the Bergers, the Borks, the people writing in the late 60s to mid 70s, late 70s, really writing until the 90s when 12 years of Reagan-Bush judges changed everything. Jack, they wouldn't have recognized originalism today. They just wouldn't. Raoul Berger and even Bork, although at the end he got kind of flighty, would not recognize this form of this kind of aggressive judicial activity in the name of originalism.
Well, we're doing. I just say it's more complicated than you put it. Let me try and make the case for your position and explain what's going on. This is actually my last book, The Cycles of Constitutional Time.
Yes, I know. Yes.
So, with respect to the Establishment Clause cases, Dobbs, and cases that cut back on Warren Court recognized liberties, Berger and these folks would be exactly in line with today's conservatives because these cases all involve judicial restraint.
Right.
Dobbs' judicial restraint case, the Establishment Clause cases are judicial restraint cases.
Yep.
So with that, the early originalists would be in exactly the same position, I think, as today's. Okay? It's really what you're talking about is the use of judicial review to promote the conservative agenda, the agenda of conservative constitutional values. That would be a little different. Now, that's not quite true because, Robert Bork didn't like affirmative action, and he thought that it was unconstitutional. William Rehnquist, who was kind of only a fair weather originalist, he didn't like affirmative action. He believed in judicial deference in almost every case except affirmative action. So that's a little bit different.
Yeah, and some free speech cases. Yes. Yeah.
But here's the grain of truth on what you're saying. When you represent a political movement that's on the outs, that doesn't control the levers of power and doesn't control the judiciary, it doesn't have a lot of friends on the judiciary, your general position is one of judicial restraint. That's because the judges are unlikely to decide cases in your way, and so if they exercise the power of judicial review, they're likely to exercise it in ways that you don't agree with. So you will generally support judicial restraint. And that explains the views of progressives and liberals before our FDR appoints.
Yeah, 1935. Yeah, 1935. Yes.
Because you're on the outs. You don't control. And the doctrine's being made by people who disagree with you. So when judicial review is invoked, it'll probably be invoked in ways you don't like.
Yes.
But as soon as you get control of the courts,
as
soon as you get control of the courts,
then
what's going to happen is your view of judicial review is going to change. And why? Because now your judges, the judges who are allied with you, sympathetic to you, are going to do a lot of good. They're going to create new doctrines that are going to protect rights you think are important, and they're going to, more importantly, they're going to supervise decisions being made by the lower courts, lower federal courts, and also by state courts. That basically these judges now who are sympathetic with your views about the meaning of the Constitution and its values are going to be doing important and valuable work, and so you need judicial review. You need that. And that's exactly what happened after FDR appointed all the justices. What you see is the birth of American civil liberties law by the liberals on the court, and also what you see now with the new conservative supermajority.
So Keith Whittington, now your colleague at Yale, who spent most of his career at Princeton, and with Randy Barnett and Larry Solomon, were probably the people most identified, among the people most identified, with Calabresi and a few others, with the new originalism of the early 1990s. Even Keith Whittington, who is not a progressive like you and me politically, even Keith has written. And the amazing thing about this next thing I'm going to ask you about, and then we'll
He
have to
pointed
call
out
it.
the same thing in an article.
Exactly.
in
No.
2001.
Keith said originalism changed at the moment in time when Reagan and Bush judges controlled the American judiciary. But Jack, I want to ask you about a bigger point, which is separate from your book. Keith said that. I know of no conservative American law professor. Keith's a political scientist, right? I know of no American conservative law professor who has conceded that point. I make it all the time in my public presentations. I make it all the time that what changed with originalism went from deference to aggression only when the people on the court changed, and now the people on the court agreed with the originalists politically, like you just said.
The answer is I'm not sure that's true. I think Harvey Wilkinson has said something similar to that.
He's a judge. He's a judge, not a law
Yeah,
professor.
he's a judge. Yeah, I understand.
No.
But he was a law professor before.
Yes, I know.
So I'm not sure, but I would say yes, on the whole, that's not the story that's usually told. But
Yes.
the reason why is because from the standpoint of conservative law professors, they understand themselves in one or two registers. One is they're just applying the law. Why are you getting in trouble?
But that's so stupid. Come on.
Right?
Come
Right?
on.
And the other register is, you understand that conservative originalism is a reform movement.
Yeah,
And the reform movement requires different strategies at different times.
fair enough.
So
That one's fair.
We had to basically stop the halt of really bad liberal decisions. And then once we had more influence on the courts, we had to start repairing and restoring the Constitution to where it should have been all along. And so that means you're going to exercise judicial review more. Well, that's what happens when you have a successful reform movement. So those are the two registers in which people will talk about it.
Yeah, I think that's a brilliant descriptive account. I think it's in a lot of your books, not just this one, and I think you're right about it. Jack, I want to promote your book one more time and then ask you one last question. And I apologize because I didn't tell you I was going to ask this question. The book is Memory and Authority: The Uses of History and Constitutional Interpretation. I think this book is important for law and not for law. I think it is about memory and how human beings react to the past. I think it is, I don't agree with every word in it, but I think it is extremely interesting, provocative, and in a lot of ways, a descriptively accurate representation of how judges actually use history and tradition in constitutional law. Okay, buy the book, read the book, it's very good. Now, my last question. Last night, or 2 nights ago, I guess, Oren Kerr wrote me privately on Twitter, and then he put it on Twitter, what he wrote me about. And he asked me a question. He said, do you think that non-originalists would be more sympathetic? And now I'm going to be very binary. You and I know this is not an accurate representation. But if we take a binary of originalists and non-originalists, which is not fair in the world, but for the moment, would non-originalists be more comfortable with originalism if our Constitution was easier to amend? Is the real problem with the Constitution that we have to have judges updated over time in a way that living constitutionalists might like, but originalists don't, because it is so hard to amend? And if we could just amend it, then if we don't like what the court does, we just amend the Constitution in an easy way, and all the stakes go down, and you and I wouldn't be having this conversation about deep theory and that kind of thing if we could just accept that we'd change Article 5. That Article 5 is the real problem in the room, is the real elephant in the room. And I'm dying to know your reaction. I did not tell you I was going to ask you this. This is off the cuff, I know. But I'm dying to know what your reaction to that is.
Well, I agree, more or less.
Okay.
But I would make an additional point.
Okay.
The biggest problems we face today are not problems about judicial review that is defining rights and liberties. I mean, those are problems, but the biggest problems have to do with basic constitutional structures. The structure of the Senate, our representational systems, the creaky system of separation of powers that we have, all sorts of problems. And those really can only be dealt with through amendment. And part of the reason, this goes back to the previous book, Cycles Constitutional Time, part of the reason that we have such dysfunction is because of features of our constitutional system that really require constitutional amendment. They have to do with the sort of bones and structure of the Constitution. that's a reason to rethink Article 5. We really need to think about how the basic structures of our Constitution work. And for that, we need to have a more flexible amendment process. So, in that sense, I tend to agree with Orrin. Now, I don't know if you know this, but in 2019, my dear friend Sandy Levinson and I wrote a series of letters to each other that became
Yes.
a book called Democracy and Dysfunction.
It's a
And
great book.
one of the basic themes of that book is we need to rethink the basic structures of representation in the United States. And Sandy took the view that we need a new constitutional convention and we really need to change Article 5. My view was there are lots of ways of doing it outside of Article 5, but my ultimate view is that Sandy's right and that we really need to change Article 5.
And I feel, because Sandy's a friend of mine as well, I feel obliged to say he's been on this hobby horse for a very, very long
very,
time.
very long time.
Yes,
Yes, that's right.
And Jack, thank you so much for doing this again. I really appreciate it. I could talk to you all day. It's been really fun. And maybe we'll do a third version, 100 podcast episodes from now. I don't know, but if there is that. But thank you so much for being here.
Thank you. It was wonderful being here, and thank you for having me.
I really enjoyed it. Thanks.